Welcome, everyone, to Voices of NCAJ, the podcast for the North Carolina Advocates for Justice. I am Amber Nimocks, your host and Director of External Affairs for NCAJ. Before we get started, I'd like to thank today's episode sponsor, Advocate Capital. Advocate is passionate about helping plaintiffs' attorneys get better results for clients, mainly through their AdvoTrack case expense funding service. It allows firms to track case expenses and recover borrowing costs, which makes the net cost of borrowing zero on cases they win. You can learn more at advocatecapital.com. I'm excited to welcome today's guest, Artemis Malekpour. A lawyer with a background in psychology and psychiatric research, Artemis is a partner in the litigation consulting firm Malekpour Ball. She specializes in jury research, case strategy, jury decision-making, jury selection, and identifying and solving case problems. Artemis will lead a session at NCAJ's upcoming CLE dedicated to evidence and pretrial motions. That CLE will be on November 7 and is the first part of a three-part trial skills series, with part 2 on November 8. You can go to ncaj.com/events for more details and to register. Artemis, welcome to the podcast.
Thank you so much for having me.
So, as part of this upcoming CLE, the program notes say that you will be showing participants how to craft a trial theme through jury selection. So, what does that mean?
So first, let's figure out what jury selection in that voir dire process is, particularly in North Carolina where you have plenty of time, more so than in other states. First, what your goal is not necessary. You don't want to be trying your case. You don't want to be conditioning those jurors. But what you do want is to be establishing rapport, establishing credibility, establishing a connection with those jurors, listening to what those jurors have to say, finding out more about who those jurors are, and then knowing what you believe, and hopefully you focus group beforehand, your theme is, asking those jurors, having conversations with those jurors about those themes. So, for instance, if your theme is based around rules, I'm going to be wanting to ask them experiences, attitudes regarding rules, how rules affect their lives, whether, especially these days, are they folks who believe rules keep us safe? Do they believe that rules are meant to be broken? I want to be asking about that. If my theme is related to responsibility, I'm going to use some of my time in voir dire to ask questions related to that. Again, having conversations with those jurors to find out what's important to them and how they talk about these themes rather than pushing our themes on them, because voir dire is your one opportunity to allow them to speak and to have conversations with them to find out more about them. And so we want to make sure that it's almost, as I consider it, kind of, volleyball. I'm lobbing up something and then allowing them to bat that ball around, see where they go with it. If damages is, your theme, if that's the main part of your case, if you got a case centered around that, I want to hear what they think about the damages case as well. But I think it's important to make sure that the attorneys realize jurors are sophisticated enough, particularly these days, to see when you're trying to push something on them and to see that you're not actually caring about who they are or what they have to say. So make sure that you're weaving the themes of your case into the conversation that you're allowing them to have about their own experiences, who they are, and what they care about, because ultimately your case is about what they care about.
So, you need to be letting the jurors tell you a story as well as getting them ready to listen to the story you're going to tell them.
What we want to make sure is, because jurors base their decisions on what they're bringing in, the experiences they've had, the attitudes they've had, the opinions they have on things, they're bringing that with them into your case. So in order to figure out, okay, ultimately, because you're not in that deliberation room with them, you're not going to be able to say, hey guys, let's talk about this. This was a really important thing. This was my theme of the case, or this was the thing I want you to talk about. You can't do that in deliberations. You're not there. So what the voir dire process is okay, who are those folks out there? How do they talk about? These are strangers, you don't know them. So again, part of what your job is during voir dire is to establish a connection with them, show that you're someone who is actually listening, and even with the questions that you're posing, that you're lobbing up, you're not just lobbing them up because they're on your outline and you're checking them off, but you're actually engaging them in the discussion. They're having the discussion. If the discussion gets away from what you think they should be talking about, you follow that discussion because, again, that's what's important to them. So you're watching that, and hopefully you're allowing, especially in North Carolina, because we do have that wonderful opportunity to allow jurors time to, I believe it may have been John Edwards, someone says, to kind of deliberate in front of you. You're allowing them that opportunity to do that. So it's really you ask questions and get out of their way and listen to how they're talking so you know where to follow up, with whom to follow up, who seemed to have a problem with what you said or what else said, and very respectively allow them to voice that. Respect being so important in this process, listening being so important as well, because you're trying to kind of you're setting a tone for how trial will hopefully go. And if you're showing in that you're trying to push your agenda on them, a lot of folks, particularly these days, are going to reject that. So I want to hear if I've got particular, especially if I've learned from focus groups, if I've learned from discovery, if I've learned from how the case has turned out during that process, when I'm coming in, I have topics that I want to make sure that we're talking about that are specific to this case. But I'm also going to make sure that I'm allowing those jurors time to have the discussion that they want, that matters to them, and finding those words that they're using. And because I'm taking the information they give me, not only to select those jurors who I want on my case, but also to take what I learned from voir dire and putting that into our case now. Because now I know what they care about and how they talk about it. So I want to merge the two. So what you learned there doesn't stop, about those jurors doesn't stop in jury selection. You're then taking that and weaving it into your case as well, with the questions that you ask, the stories that you're getting out of your witnesses, the story that you're crafting in the opening, all of that, because you want it to connect and to resonate with those jurors so they can understand, this is why I'm here, this is why I care about this case.
So there's so much more than a legal education in informing this process.
Absolutely.
You're coming to this with a background in psychology and psychiatric research. How did you get involved in the line of work that you're doing now?
So I took a weird path to get here. Initially, my dad is a psychiatrist. I grew up in the mental health field. I did some interning with him when I was in high school. I was a psychology major in college. I thought psychology was fascinating, how people think. I am an introvert, so a lot of my time is spent watching other people and seeing what they do, why do they do it, and I'm also critical to a fault. It helps in my line of work, but I'm also in my head being very critical and analytical about what I'm seeing and what I'm watching. And so initially I thought, okay, maybe I wanted to go into psychology, maybe I wanted to go to psychiatry. I worked in the Department of Psychiatry at UNC hospitals after I got my master's in public health, and still thinking maybe I wanted to do medicine, but then realizing that the topics that were interesting to me weren't about the medicine, which is ironic because I do med mal cases, so I have to learn a lot of medicine for what I'm doing here. But it was actually the legal aspects of, in this case, medicine, because that's the field I was in, but it was the legal aspects that were fascinating to me, whether it was related to bills that were being considered at the time. When I was in grad school, there was a guilty but mentally ill bill that was being batted around, and that was fascinating to me. And it was related to Wendell Williamson and the psychiatrist, and then who was sued from UNC. And then when I got to the Department of Psychiatry, working as a social research associate, the psychiatrist who was part of what I was doing in grad school actually came to speak about the court case against him. And I was thinking at the time, because they have ground rounds on Fridays, and there'd be ground rounds about dopamine and serotonin and all that, and it just I was like, it's not really fascinating to me. But when he came, because I'd already been interested in the case, I just thought this was the most wonderful thing. So I got there early because I wanted to make sure I figured everyone's going to be clamoring to listen to him. And I was there for like an hour waiting for people to show up because they were just going to show up on time and they didn't really, it was just another case of them. And then I realized it was just listening. And meanwhile, I had this fascination. I realized, okay, I think I'm in the wrong field because I think this is the end all be all of we should all be caring about this. And they're like, go back to, patient do whatever. So then when I realized, okay, law is really actually where my interest is the connection, and especially as I was watching our patients in the Department of Psychiatry, they were kids, they were adolescents, they were children who were stumbling upon legal issues along the way in their treatment. And again, that was the part that interested me most. So I did a detour and I went to law school thinking that I wanted to work in public interest. I wanted to work with kids who had mental health issues and legal challenges. So that's kind of the path I took. And then that summer between my first and second year, I worked with Advocates for Children's Services, which was part of legal aid. And I worked with amazing attorney Lewis Pitts and watched him just fight for those kids, for their actual interests rather than what someone else deemed their best interest to be. And I saw his fight, and within a week, I both was so admiring what he was able to do, and also realizing that because I have way too much empathy, I would never be able to do that. It would just crumble me because here were kids not getting the, you know, basic education services, health services, school, placement, home placement, things that basics that they needed. It was a fight. It was a fight with the system. It was a fight with everyone. I was like, okay, I will crash. I will not be effective because everything made my eyes tear up. So I had got my second year law school curriculum all set out, and it was all related to going down that public interest field and then realizing, okay, that's not really what I think I should be doing. I don't think I'm going to be very great at that. I went to the law school that summer and talked with Neil Vidmar, who was the only psychology professor in the department at the law school at Duke. I was going to law school on the dark side. And so I went to him, I asked him to talk because I was like, okay, your psychology, that's what I want to do, but I feel like again I'm lost. It was kind of how I felt in the Department of Psychiatry at UNC hospitals. I was like, okay, I feel like I'm close, but I still am I've lost my way a little, and I don't want to do what everyone else is doing. And he said, well, there's this thing called jury consulting. And he mentioned the jury consultant that was in the O.J. Simpson case. And he was like, there's this thing, and then there's this guy in Durham, his name is David Ball. maybe you want to meet with him. So I reached out to David. We met at Elmo's in Durham, and he talked to me about what he did. And he said he had a focus group coming up, and it was going to be in Winston-Salem. And if I wanted to go, I could attend. So I went. Case was fascinating. Listening to the case, but also watching the jurors interact with the case, and particularly at that session, David just happened to bring in the client to do a direct and cross on the client, right there, the actual client in the case, as opposed to showing video, and then watching those jurors react to her coming into the room based on what they heard her damages were versus what they were seeing. Um, and then David, being David, rather than allowing me to sit back and watch, said, okay, these folks are going to deliberate. You take these groups of folks and do a discussion group with them. And I had at this point, again, I'm an introvert. I am used to just watching, not actually doing. And so I was like, what the heck is a discussion group? And what am I supposed to do? And I got in there, and it was the most enjoyable time. I just felt, okay, this is home. This is what I should be doing. And we drove back from Winston-Salem that evening back to Durham, and I just could not stop talking about my experience and how fascinating it was listening to them talk about what they heard, what they saw, where minds changed, and then also kind of confirming what I thought I was seeing in them. And so I changed my whole second semester schedule on that fall semester. David was gracious enough to say, okay, I don't usually take on people. At that point, he did have one partner that that he was working with, but he was like, okay, usually I don't do this, but okay, you can do an internship with me. And then he had me starting doing jury interviews. And so through that path, by the time I finished law school, I took the bar just in case I ever needed it, my license. But I just took off from there and went down my trial consulting path, and that's been 20 years now. It's a very long answer to your question, but that's how I ended up doing this.
Well, it's so interesting because it's such a huge part of, most people don't understand that psychology and mindset has absolutely nothing to do with logic and the law and the way that the law is written, I mean, that's
Absolutely.
like it's such a crucial friction point.
Absolutely. And also what was interesting, it was more confirmation. I took trial ad because David's like, you should probably take trial ad my third year, just to know kind of what they're doing and stuff. And so I took it, and I took it with Don Beskin, who I adore. And I remember, because at the end of that semester, there's a mock trial, and if you're on either side. And after that trial, the attorneys go into another room and watch the jurors deliberate. And I remember just being fascinating listening to those jurors deliberate about the case that we had just tried. And I am over here watching them. And meanwhile, my fellow students, the attorneys from this trial ad, were over here talking about how they thought they did, and how effective they thought they were and all that stuff. And meanwhile, we have these folks in front of us who are the decision makers, and how we all thought we did had nothing to do with the case or what ultimately mattered, which is what they thought. And so that again was another one of those moments of, okay, actually the attention should be here, not here. And as you said, it's not about logic. It's not about how well we did. It's about how it made those jurors feel. What did it spark in them? How did they decide based on things that have nothing to do with logic, that have nothing to do with anything rational or reasonable or anything that we think? There is a method to the madness, as you might, I hate to use the word madness, but the idea that it's coming from somewhere. And ultimately, our job is what is driving those decisions? And the only way we know what's just driving that decision making is to listen to them. And it's not what they say, it's how they say it. And ultimately, by doing as, David teaches, Eric Oliver teaches that tell me more, say more, what else? It's not that first layer, but it's two or three or four layers in until you realize, and that's what the beauty of the gift that we have in the jury selections in North Carolina is you do have that time to explore. And again, like I said, it's not the conditioning and the attorneys doing all the talking, trying to lecture those jurors to put them in some place, but it's more of, okay, let us meet jurors where they are. Let's go to where they are as opposed to trying to drag them to where we are. And so in that process, that's the listening, and it's not the surface level, but ultimately three or four, you know, tell me more is deep is where you find out, oh, that's what's driving that decision. And it's the same thing as, I do a lot of looking on the internet, whether it's Twitter, Facebook, I look at comments, articles, whatever that is. And it's not, I love threads because, when you see on Twitter, when there's a thread, they have their initial opinion, whatever that opinion they're expressing, and then they'll talk more and more, and especially if there's a back and forth. And then ultimately down the line, I'm like, oh, yes, that's why you care about this, and that's why you're saying what you're saying. It's not actually the surface of what you're saying, but there's something else driving that. And again, that has nothing to do with logic. You think that, oh, people should care about this, but that is not necessarily what they care about. And why is that? Let's figure that out, the why and the how behind it.
Yeah. Wow. Yeah, that's interesting. That must be a wealth of information, all the ways that people will share their opinions on. I'm always fascinated by how much people will share, particularly on like sites like product reviews.
Oh yeah.
Like I was trying to buy a new robot vacuum the other day, and I could not believe the level of analysis that people will give you unsolicited about robot vacuums, and they'll return
Hmm.
later. I want to provide you with an update on my robot vacuum. So it's yeah, like I
But
guess
think about
that's
that. Why is that? Like,
yeah, why? That's
and
interesting.
it goes back to what I mentioned in the jury selection, and it's the respect and it's the time you're giving those jurors. People want to feel important, they want to feel respected, they want to feel needed, they want to feel that what they have to say matters, that they have an influence on something. And so that's what you're trying to establish in voir dire. You're trying to show them that you do care about what they have to say. You do respect, even if you disagree with what they have to say. You respect it. You want to hear more. You're not trying to change minds. They're the most important people in that jury, in the courtroom. And what they do matters. They can influence change. And coming from the plaintiff's side, if part of it, they don't, some people, I won't say it, like there's a decent number of folks who don't really care about the plaintiff and what happened to the plaintiff. And, we all have stuff and we all got problems and stuff happens and we all deal with it. And I didn't get money for that. And, but if you can frame the case in a way that I can see you've empowered those jurors to see that a verdict for the plaintiff is really a verdict for them, the community, and they have a say, they have a voice, an important voice, and they can influence change and change that matters to them in a direction that matters to them, that affects them and theirs. And they did that. That's hugely important. So go into your product reviews. Why am I wasting my time on it? Some people just, I'm so mad at this company. I'm so mad. I hate what this is. So I'm just going to, just really slam them. That's why I'm there because I'm getting my frustration out. But a lot of times people are doing it because I feel my opinion is important and I want to sway you or tell you what that is. I want to share that. So it's tapping into that, and that's what we're trying to do also in voir dire and being respectful of. I really think what you're saying is important, and I want to hear that. And then I'm going to demonstrate in this case why this should matter to you and what you can do about it.
So yeah, it's fascinating. It is. Yeah, and I do find it's those product reviews, those opinions people the ones that I find most fascinating aren't the ones that are angry. They
Right,
just want to tell you. I
right.
really liked how like the suction on this one was much more powerful than the previous model, and I was really impressed with that. And they just have the need to express that. And I mean, it's so interesting, we're in the middle of this election and, like the big question is how to persuade the unpersuadable voter, but and everybody's like, well, I don't know what I could say to persuade anybody, but maybe it's more about first doing the listening before you can persuade anybody of anything, right?
Yeah, finding out what do they care about, what do they want to talk about, and how am I addressing their concerns? And, you know, politics, anytime I lecture, I tell folks, as much as we kind of don't want to bring politics in, and I certainly wouldn't bring politics into a voir dire if I want my jurors to be all together. But we can see politics very much informs trials because you're seeing politically the language that's being used, what folks get riled up about, how they cling to things that seem to defy logic, particularly in the position that they're in. Why are you supporting this candidate? This candidate has said all these things. Has it done anything that has helped you? Their policies actually would hurt you, but yet so you're so ardently, strenuously for them. What is that about? What's turning you off about this candidate? And a lot of what frustrates me about politics that we can learn from is that if you disagree with someone, let's say you disagree with a particular candidate, and then you, instead of learning why others support that candidate, you mock those people for supporting them. So instead of trying to learn and trying to understand, you mock them for either being too stupid or you mock the candidate for how they speak, what they say, and you logically or intellectually don't understand why people would like that person. So take that attitude and then you're going to put it in the courtroom, how you view those same people until you learn to respect it, to really understand what makes that candidate appealing to these people, you're never going to truly understand those people. And again, those people are going to be some of your jurors that end up in your trial. And so I worry too often that we dismiss things or we belittle things or belittle people because it doesn't match with what we think people should care about or what we think of a particular candidate and we believe others should care. We try again, is that trying to bring them to where you are as opposed to going to where they are? And you just can't do that, and particularly these days. These days we are so rooted in our opinions. And if you set out to try to change my mind, and particularly if you do it with things that I think are tricks or I think are lies or whatever that might be, I'm already against you. If I think you're trying to manipulate me in some way, I'm already against you. You're never going to get me to get on your side.
Right, right. Yeah. So, what are some of the things that folks who participate in the CLE upcoming can expect to learn? You're gonna do like a practice session voir dire based on practice case, right?
Correct. I think it's based on a real case.
Well,
So
based
it,
on a
I
real
think,
case, but it's going to be
mhm,
basically a mock trial with a voir dire in advance.
correct.
And so, what are some of the takeaways that folks can expect?
Well, first, I think this is an excellent session because this, rather than having people lecture to you, you're going to be in the midst of watching. And again, same as my trial ad folks, it's you're certainly you're going to watch what the attorneys are doing, but ultimately you're also going to want to hear what those jurors say and how they talk about it in deliberation. And so what I'm doing on my day, working with the attorneys, they're going to do voir dire and we're going to critique that, and we're also engaging the attendees. So this is not one of those sit back and watch. This is actually going to be participatory, and I'm hoping it's brainstorming. I'm hoping that they come ready to be engaged, ready to talk, ready to see, okay, how did that work? The framing, the phrasing of words, of, ideas, of concepts, of sentences. Did jurors get it? Did they not? What did they do with it? Where did they take it? And then ultimately, with the responses that we get from those jurors, who makes that? Who should be on that jury? Who, based on, to go from the plaintiff side, who do we think are those, quote, good jurors? Who do we think are going to be helpful jurors? What are we looking for in a juror? Are we looking for, folks who have had like experiences or not like experiences? Do we want leaders? Do we want followers? What do we think based on the responses that we got? And again, not just what they said, but how they said it. What do we think about the perspective of that juror? And the great thing here is then you have that ability to see where you're right, where you're not, in how they discuss in deliberations, and then also what changed folks' minds. What were those group dynamics? And did we see those dynamics forming in that voir dire? There's so much to see, to learn in that voir dire jury selection process. And so I really encourage folks who are attending to come eager to be part of it, not sit back and watch, but eager to be part of it and to learn and to really dive in. I think that's the intent of this, is to be interactive and to then be able to feel comfortable going in to trials, especially because law schools don't really, you do have trial ad, but after there's not a lot of practical application of things that happens. And this is that opportunity. And then the opportunity to ask questions, to be involved, and to really get into it. I'm so excited about this because of that interactive. It's my favorite format. So I'm really thankful that folks put this program together, because I just think it's going to be a great chance for attorneys.
Yeah, I do too. It's going to be an awesome program, and we are super super lucky to have you being a part of it.
Great.
Thank you so much for doing the
Yeah,
program and for
absolutely. Thanks.
being on the podcast today. I really enjoyed our conversation.
Well, thank you so much. I did as well. And I look forward to seeing folks on the 7th.
November 7th. Yeah. So
Yes.
the program is the pretrial program is November 7th, and that will feature Artemis Malekpour as doing a voir dire and an interactive session on that. And the November 8th program will be all about the trial with the same set of facts, same case. And you will, if you participate on both days, you can follow the mock trial from beginning to end and including jury deliberations. It'll be a great program. You can go to ncaj.com/events to register, and we hope to see everybody there. Thank you again, Artemis, and
Thank
thanks
you.
everybody for listening.